The U.S. Supreme Court invented a Marxist dictatorship based on 2 lines in the Constitution. The executive power shall be vested in a president. He shall take care that the laws be faithfully executed. Justices translated this to say, only the president can supervise or harm people. The only way it can be decided what to supervise or whom to harm is by voters electing the president. The majority perceptions of the collective are the only way to convey what anybody should do. All they are saying is collective decision-making is best, so the president should be able to do whatever he wants, under influence of the dominant social perception formed in the town square. But they package this Marxism inside spurious separation of powers arguments in Morrison v. Olson, Lujan v. Defenders of Wildlife, Seila law v. Consumer Financial Protection, and Trump v. United States. Justice Scalia replaced laws from Article 2 with public interest in Lujan. Anybody who asks courts to do things or whose actions benefit others is the president. The only way to discover the public benefit is the majority perception in the public square. The president is the representative of this popular will. Therefore, the president can do whatever he wants and nobody else can say anything about it. Their logic basically says you can't sue anyone because only the president can ask courts to do things, but they insulate the silliness of their logic by only applying it in narrow situations, as an excuse to do what they want in those situations. They use it in Lujan to say Congress can't create individual property rights in the environment, and in Morrison v. Olson to say Congress can't create a prosecutor to harass the president all day. In Bessent v. Dellinger, petitioners argue the Office of Special Counsel must be an agent of the president because only the president can do things. You might try to say only the government can ask courts to put people in prison for the public interest, and only the executive branch of government does this as their job, rather than only necessary to their job in aid of their jurisdiction. But private plaintiffs can have people jailed for not paying civil judgments. And our whole system of property rights is designed to make private decision makers employ their property for the public benefit. A landlord sues a roofing contractor for the benefit of his tenants, on whose behalf law and prices supervise the landlord to act. So a landlord prosecutes civil defendants and has them jailed for the public interest in his sovereign domain. Justices basically say, the president wants to do X, and here is some logic that is so incomplete you cannot even argue with it, but only accept it if you like the conclusion. These silly arguments are only accepted because Marxism, like the collective supervising industry, is always politically popular. Marxism is by definition forcing everyone to do what is politically popular, rather than have private decision makers decide things based on specialist knowledge, local information, and incentives conveyed in laws and prices, without being harassed by political impulses. Trump v. United States said, investigative and prosecutorial decision-making is the special province of the executive branch. This doesn't even really mean anything. A judge can dismiss a case based on an investigation by a defendant. Congress and courts can investigate and initiate accusations in aid of their jurisdiction, including contempt leading to prison. DC cops can arrest congressmen and shoot them if they resist, but they're still not agents of the president. Trump v. United States said, the Constitution vests the entirety of the executive power in the president. Every actor, from business owners to judges to government officers, uses discretion to make decisions within the boundaries of law based on the information at their vantage point. Private parties assert their rights to make accusations in court to have the law enforced against the government and other private parties. The discretion of private property owners is supervised by the price system. The discretion of elected officials is supervised by the voters. Courts, juries, legislators, voters, consumers, and prosecutions, initiated by public and private plaintiffs, all regulate such behavior of decision makers, both government and private, to serve other people's interests. A desire to simplify that to one person centrally planning and enforcing the public will is basically Fidel Castro. In Bessent v. Dellinger, petitioners argue, since the Office of Special Counsel does things, he must be acting on behalf of the President. The Office of Special Counsel does not exercise power on behalf of the President, but on behalf of the domain and duties given to him by law. The Office of Special Counsel does not act on behalf of the President any more than a jury does, but they use this silly logic that says if someone is asking a court to do things, he is performing executive functions and therefore must be acting as an agent of the President. Seila Law v. Consumer Financial Protection said, because no single person could fulfill that responsibility alone, the framers expected that the President would rely on subordinate officers for assistance. A market economy relies on distributed decision-making by infinite decision-makers. The Constitution was written for agricultural societies before the Industrial Revolution was well understood, such as in Adam Smith's Wealth of Nations, and before the collective sought to make industrial decisions. But the Constitution did not intend that every decision in society would be made by a dictator, thus necessitating a lot of subordinates like the USSR. Obviously, collective perceptions cannot tell the executive branch what the farmer should plant or how much bread the baker should bake. But if the founders imagined that political surveillance would force the executive branch to enforce or even obey the law, they were wrong. The people will monitor outcomes, not whether executives follow rules. And most people do not perceive any benefit from the middleman of courts and laws. The people will want outcomes in particular cases, regardless of what the law called for in cases in general, and based on popular perceptions which are different from facts in court. The people don't know what the facts are in individual cases and cannot know. The people will not even be aware of most cases and decisions, leaving local parties to fix most outcomes in the way most convenient to their own agenda. Every part of the Constitution is designed to force the executive branch to conform to laws and processes and restrain the executive branch from interfering with other decision makers. Rather than simply do what the majority faction wants, the executive power is constrained by advise and consent, by laws and process rights, by the 25th Amendment, by impeachment, and so on. Courts can order the executive branch to do things with writs. The executive power is intended to be constrained and steered by the other branches and independent actors known as checks. The right to a jury trial and making a judge the finder of fact of probable cause are both examples where the law designs checks on the executive branch activities. Jurors are not the executive, legislative, or judicial branch of government and intentionally do not answer to any voters. The executive officer cannot choose to remove these judges or jurors who direct the activities of the executive branch. So one can scarcely imagine that the Constitution celebrates this regulation of the executive branch by the people as much as Marxist judges like Scalia have invented. Seila Law v. Consumer Financial Protection said the President is the most democratic and politically accountable official in government. There are other kinds of accountability, such as being accountable to the law and courts. Politics does not force a president to faithfully execute laws. If anything, the faithfully provision in the Constitution says the president is subject to courts and laws, not to the people. It says that, at least as clearly as it says some power is vested exclusively in the president. The Office of Special Counsel is a separation of powers to create checks by faithfully executing the law. Seila Law v. Consumer Financial Protection said if there were other decision makers not subordinate to the president could not be held fully accountable for discharging his own responsibilities. The buck would stop somewhere else. That is not prohibited but designed in the Constitution. For example, judicial errors at criminal trials. An election every 4 years is not the entirety of supervision of the executive branch. The whole point of the separation of powers and of distributed decision-making in general, like the two-person rule in missile launches, is to create independent checks. Accountability by the public monitoring the behavior of government employees is silly. As silly as if voters tried to monitor the behavior of McDonald's managers by examining their books and voting to govern their management decisions. The collective is just not a good developer of expertise and processor of information, and its majority vote is a poor regulator. The question comes down to, is a person other than the president who harms people, such as the office of special counsel, stealing from the right of the majority who elect the president? Given the office of special counsel is appointed by a president and regulated by courts and the president to enforce the law passed by the legislature, he cannot do anything not created by the will of the people. The Constitution does not prohibit anyone other than the president from harming people, or prohibit some check other than the majority will of the collective from saying who should be harmed. And nor could the Constitution ever be amended to say that. Harming people is not some magical property created uniquely in a particular office in government. Harming exists without law, then law and courts refine harm. And governments are an ecosystem of harm collectives for people with common interests, like a school or club. If you only recognize the collective will of the majority as a valid means to convey preferences, and only to a single executive branch, then you are a Marxist. And your conclusion is followed from this misguided thinking.